Citizenship on the Go. Lesson 4. American History. Civil Rights. Part 1. Racial Discrimination and the Constitution. This lesson explains some of the history, tactics, and results of the women's suffrage movement and the civil rights movement in the United States. It discusses methods Americans used in the late 1800s and in the 1900s to petition the government to end many forms of sexual and racial discrimination that were authorized by federal, state, and local laws of the time. Most especially, this lesson describes how civic groups and activists of the 1800s and 1900s fought for equal voting rights by exercising their freedom of speech, freedom of expression, freedom of assembly, and freedom of the press, as well as other freedoms listed in the Bill of Rights. In the 1800s and toward the start of the 1900s, women in most U.S. states could not vote. Additionally, even though the Constitution was changed after the Civil War to state that it was legal for male U.S. citizens of all races to vote, Black Americans of any gender often had their voting rights denied by state and local authorities. Before and after women won the constitutional right to vote, Black people, Native American people, Asian people, and other non-white people living in the USA were subject by law to many forms of racial discrimination. Activists like Susan B. Anthony and Martin Luther King Jr., among hundreds of thousands of other people, worked for equality for all Americans by helping with campaigns, writing to newspapers, and using other methods to publicly support or oppose policies of their day. People involved in the women's suffrage movement and in the civil rights movement petitioned Congress and appealed to the Supreme Court for better protection of the basic rights of all Americans, resulting in important changes to the law of the land and how it is applied to us today. Nowadays, we often use the title Civil Rights Movement to label the campaigns of the 1950s, 1960s, and 1970s, in which many thousands of Americans participated in pursuit of equal freedoms for U.S. residents of all races. The civil rights movement in the United States tried to end racial discrimination. People of all races participated in the civil rights movement, but this period of U.S. history is especially recognized as a time when Black Americans organized large-scale, nonviolent protests to try to secure equal rights for everyone in the country. When people talk about the civil rights movement today, they're most often discussing how Black Americans like Martin Luther King Jr. used demonstrations, boycotts, speeches, court cases, and the press to petition the government for an end to racial discrimination. Racial discrimination comes in many forms. After the Civil War, slavery was outlawed throughout the United States by the 13th Amendment to the Constitution. However, in the late 1800s and early 1900s, economic, legal, and social bias in favor of white Americans and against non-white Americans was very common in every state. Public policy was especially stacked against Black people who had formerly been enslaved, their descendants, and other African Americans regardless of family history. A major form of discrimination that was enforced by law, in Southern states in particular, was segregation. In states with segregation, public spaces were strictly divided between areas reserved for white people and areas reserved for Black people. Where a person was allowed to sit on public transportation, in movie theaters, in restaurants, in parks, and more was determined by race. States where segregation was enforced had separate water fountains, separate public bathrooms, separate hospitals, and separate schools for people of different races. Systems of segregation were especially put in place to keep white people and black people apart, but they applied to people of other races as well, including Native Americans, Asian Americans, and Latino people of all backgrounds. African Americans, in particular, also faced discrimination in employment and in housing throughout the United States. In a majority of states in the early 1900s, it was illegal for a black person to marry a white person. People involved in the civil rights movement tried to end all these forms of discrimination and more. Civics test question. What movement tried to end racial discrimination? What movement tried to end racial discrimination? The Civil Rights Movement. The Civil Rights Movement tried to end racial discrimination in the United States. Civil rights and public freedoms in the United States are closely tied to the U.S. Constitution. The Constitution sets up the nation's government, which is supposed to be of the people and work for the people. It defines the government, explaining what the different parts of government are and how they work. By laying down rules about what the government is and isn't allowed to do, the Constitution also protects basic rights of Americans. The Bill of Rights, in particular, has a lot to say about the basic rights of everyone living in the U.S., citizens and non-citizens alike. Since the Constitution is the supreme law of the land, every state government and every local government in the country is required to recognize the basic constitutional rights of all people living under their jurisdiction. No government in the U.S. officially has the power to make laws that go against what the Constitution says. Even though the Constitution protects basic rights of Americans, in the 1800s and early 1900s, women were denied the right to vote in most states. Well into the 20th century, many states, particularly southern states, had laws protecting segregation and other forms of racial discrimination as well. Throughout the civil rights movement, African Americans and other minorities were regularly denied rights that the Constitution is supposed to guarantee to everyone living in the United States, including the freedoms of expression, speech, and assembly. Many times in U.S. history, up into recent decades, state and local governments have gone against the Constitution by using race or sex as a reason to deny certain Americans the freedom to petition the government, the right to bear arms, or the freedom to do other things the Constitution describes as rights of everyone living in the U.S. Government officials attempting to deny Americans their constitutional rights on the basis of race or gender are acting against the supreme law of the land. When a state government acts unconstitutionally, it is the job of the executive branch of federal government to step in and enforce the law. This happened sometimes during the civil rights movement. Civics test question. What does the Constitution do? What does the Constitution do? Sets up the government. The Constitution sets up the government, defines the government, and protects basic rights of Americans. No level of government in the United States is allowed to take away the basic constitutional rights of people living in this country. Civics test question. What are two rights of everyone living in the United States? What are two rights of everyone living in the United States? Freedom of speech and freedom of assembly. According to the Constitution, freedom of speech and freedom of assembly are two rights of everyone living in the United States. Some other rights of everyone living in the United States are freedom of expression, freedom to petition the government, freedom of worship, and the right to bear arms. Additions can be made to the Constitution if a majority of lawmakers in Congress and in state governments are persuaded to vote in favor of a proposed change. Changes or additions to the Constitution are called amendments. As a result of the dedicated work of Americans like Susan B. Anthony and Martin Luther King Jr., who fought for civil rights, some very important amendments were made to the Constitution in the 1800s and 1900s to guarantee all Americans certain basic freedoms regardless of sex or race. 4 amendments about civil rights that were added to the Constitution in the 1800s and 1900s are specifically about who can vote. Before these 4 amendments were made, in much of the United States, only white men who were at least 21 years old and who had money could vote. Today, through these 4 amendments, the Constitution protects the rights of citizens 18 and older to vote, no matter their race, gender, or level of income. After the Civil War and the abolition of slavery, the 15th Amendment promised all male citizens the right to vote, no matter their race. Thanks to the women's suffrage movement, U.S. citizens who are not male also now have the constitutional right to vote. Thanks to the civil rights movement, no matter where someone lives in the United States, they do not have to pay to vote. And, most recently, thanks to campaigners in the 1900s, citizens 18 and older can vote. Civics test question. What is an amendment? What is an amendment? A change. An amendment is a change to the Constitution. You could also say that an amendment is an addition to the Constitution. Civics test question. There are 4 amendments to the U.S. Constitution about who can vote. Describe one of them. There are 4 amendments to the U.S. Constitution about who can vote. Describe one of them. Citizens 18 and older can vote. The most recent amendment to the Constitution about voting rights says that U.S. citizens 18 and older have the right to vote. 3 earlier amendments changed the law of the land by saying you don't have to pay to vote, women and men can vote, and a male citizen of any race can vote. The Supreme Court of the United States has often played a notable role in the fight for civil rights. The Supreme Court is the highest court in the land. The 9 justices, or judges, of the Supreme Court meet in the nation's capital, Washington, D.C., to carry out their duties. The Supreme Court meets in Washington, D.C., because the heads of all 3 branches of federal government work in the capital. The Supreme Court is at the head of the judicial branch of government. The word judicial is related to the word judge. Because of the system of checks and balances set up by the Constitution, there are certain things the judicial branch can do and certain things it can't do. For example, the judicial branch does not have the power to make new laws, to enforce the law, or to set taxes. Those powers belong to the other 2 branches of U.S. government. Instead, the 9 justices of the Supreme Court, as well as other people who work for the judicial branch of the government, have the job of making decisions about laws that already exist. The judicial branch reviews laws, explains laws, resolves disputes, and decides if a law is unconstitutional. When a court resolves a dispute, that means that the court makes the final decision about a legal disagreement. Since the Supreme Court is the highest court in the United States, It is usually asked to resolve disagreements about the highest law in the United States, the Constitution. Unconstitutional means against the Constitution. If the Supreme Court decides that a law Congress or a state government has made goes against the Constitution, that law is canceled. Since the Supreme Court is the highest court, its decisions are final and apply to every person and state in the country. In the 1800s and 1900s, Americans who were denied basic rights guaranteed by the Constitution often appealed to the Supreme Court to protect their freedoms by canceling federal and state laws they argued were unconstitutional. Civics test question. What does the judicial branch do? What does the judicial branch do? Decides if a law goes against the Constitution. The judicial branch, especially the Supreme Court, decides if a law goes against the Constitution. More broadly, the judicial branch reviews laws, explains laws, and resolves disputes or disagreements. Even though the Constitution is supposed to protect the basic rights of all Americans, the Supreme Court has not always ruled to be unconstitutional laws denying people living in the United States basic rights. For example, before the Civil War, when slavery was still legal in many states, a Black man named Dred Scott argued that he should be free by law after living for many years in territories where slavery was not permitted. Scott had been born into slavery, but he argued that after being a resident of territories where slavery was illegal, his enslaver, Sandford, should not be allowed to force him to work as a slave again, even if Scott moved back to a state where slavery was permitted by law. 7 of the 9 justices of the Supreme Court, however, decided that the Constitution did not prohibit Sandford from enslaving Scott again now that he was living in a slave state. The court ruled, in the case Scott versus Sandford, that people of African descent were not U.S. citizens and therefore not protected by the Constitution. Because the Supreme Court is the highest court in the country, its decision was final. Lower courts did not have the power to make different decisions about U.S. citizenship for Black people born in the United States. In order to alter the legal citizenship status of Black Americans like Dred Scott, a change had to be made by federal and state legislatures to the Constitution. Only after the constitutional definition of citizenship was amended by the legislative branch would the highest court of the judicial branch make different decisions about cases like Scott's. After the Civil War, the passage of the 14th Amendment prevented the Supreme Court from ever again ruling that someone could not be a U.S. citizen because their ancestors came from Africa. The 14th Amendment to the U.S. Constitution was designed by Congress specifically to address the status of people who had been in slavery before and during the Civil War. This amendment states that anyone born in the United States under U.S. jurisdiction is an American citizen. Most Native Americans were excluded from this amendment's definition of citizenship because at the time they were considered to fall outside U.S. jurisdiction in certain regards, but the situation was different for Black Americans. With the passage of the 14th Amendment, most people of African descent living in the U.S., including those who had been born into slavery, were now recognized as citizens of the United States and as citizens of the respective states in which they lived. Even though Black Americans were now officially citizens of the United States, until the passage of the 15th Amendment a few years later, many state governments had laws in place to prohibit Black men from voting. Denial of Black citizens' right to vote was not only widespread in the South, but enforced by the laws of many northern states, such as Connecticut. For this reason, Congress created the 15th Amendment to the Constitution, stipulating that U.S. citizens should never be prohibited from voting in state or federal elections on account of race, or because they had been in slavery in the past. When the 15th Amendment was passed, it became unconstitutional for state governments to enforce laws turning male citizens away from the voting booth because of their race. Although the 15th Amendment was a large step forward for voting rights in the U.S., it did not end racial discrimination and access to participation in American democracy. According to the Constitution, male citizens of any race could now vote, but many states required citizens to pass a reading test or to pay a poll tax before they could vote, criteria that were by design much more difficult to meet for most former slaves than they were for upper-class white citizens. Use of unfairly designed literacy tests and poll tax requirements prevented many working-class Americans of all races from voting, but these schemes had a disproportionate impact on African Americans. For many decades, Black people in the U.S. were largely denied meaningful representation in government. The 15th Amendment also only affirmed the voting rights of male citizens of the United States. The rights of American women were not addressed by this change to the Constitution, only the rights of American men. While the 14th Amendment made Black Americans citizens by law, and the 15th Amendment specifically recognized that Black male citizens had the right to vote, these additions to the Constitution were not enough to ensure that the Supreme Court would recognize other basic rights of non-white Americans. Toward the end of the 1800s, a case regarding racial segregation on public transportation was brought to the Supreme Court. A Louisiana man named Homer Plessy, who was of both African and European descent, argued that because the 14th Amendment defined him as a citizen, he had the same right to use of public spaces as any other citizen, regardless of race. Plessy had been arrested for riding in a train car marked Whites Only in Louisiana, where state laws supported racial segregation. In Plessy's day, some U.S. politicians defended segregation by arguing that the 14th Amendment did not prohibit discrimination by individuals, only by the government. Another common pro-segregation argument was that dividing Americans by race created separate but equal facilities. Pro-segregationists argued that as long as separate train cars, schools, voting booths, bathrooms, or parks were considered equal in quality, practices of racial discrimination were not in violation of the part of the 14th Amendment that called for the same protections to be given to all U.S. citizens. In the case of Plessy versus Ferguson, the Supreme Court agreed with the argument that segregation was not unconstitutional as long as facilities were supposedly equal. One of the 9 Supreme Court justices was not able to be present for this ruling, but 7 of the justices who heard the case said that while the 14th Amendment made African Americans citizens, it did not make it a requirement for governments or for businesses to abolish distinctions based upon color. Only one justice disagreed. Plessy had lost his case. Louisiana and other pro-segregation states were allowed to continue making legal distinctions based upon color as long as they kept up a flimsy pretense, or guise, as the dissenting Supreme Court justice had put it, of giving equal accommodation for whites and blacks. The highest court in the land had made its decision. The issue of segregation continued to stir up intense controversy at national, state, and local levels of government, but by law, in the early 1900s, the practice was permitted throughout the United States due to the Plessy versus Ferguson ruling. Civics test question. What is the highest court in the United States? What is the highest court in the United States? The Supreme Court. The highest court in the United States is the Supreme Court. Decisions from the Supreme Court are final and can't be appealed because there is no higher court in the United States than the Supreme Court.